Good morning and welcome to the David and David on Real Estate podcast. We are today on episode 106 and we have David Korman in the house here. And today we're going to be talking about an issue that we've been talking about for a while now. I think, David, the first episode we did on this was back in June of 2023. We were one of the first podcasts to really take on this issue and discuss it. But there's been some major updates on the NAR collusion lawsuit. So we wanted to do a follow-up session and really talk about this decision that was rendered at the end of October and really what this means for our industry here, because a similar lawsuit was filed in Canada that is just going through our court system as well. So that was a long intro. Welcome back, everybody. And, really looking forward to this episode of the David on Real Estate podcast.
Yeah, it's always great to have the next episode going. And when we come up with these topics, and I give you credit for coming up with these topics all the time and getting our thoughts and itineraries together. So thanks, David. I'm sure thank you in the past, but I can't thank you enough. But just to break down so people understand what we intend to talk about in this episode, the NAR decisions, it's the National Association of Realtors in the U.S. Okay, that's not Canadian law. It's not a Canadian decision, but this is something that happened in the U.S. where there was a lawsuit filed against the Association of Realtors there, saying that there's price fixing, colluding in the industry, and they name certain brokerages. If you correct me if I'm wrong, David, they name certain brokerages in it, and they go to trial and. Oh, there was a settlement. My understanding was there's certain brokerages sort of settled without acknowledging anything was wrong, but they just decided to pay something to get rid of it. But
that was interesting to me, David, when that happened, because Anywhere Realty, owns brands like Sotheby's, Coldwell Banker, Century 21, Better Homes and Gardens, Compass Realty. Like they're one of the largest brands or umbrella brands in the industry. And Remax were the two that decided to settle before the jury came to its decision. So, when that happened, that sent a very clear message to me as, somebody who really pays attention in the industry, that there's something more going on here than meets the eye. Because if these people are settling for, hundreds of millions of dollars, I think they each settled for about 100 million. Then that leads me to believe that they believe that come the day that the jury makes a decision, that the jury is heavily leaning towards rendering a certain type of verdict. So, and this was very reflected in the stock market. I look at the stock market all the time when it comes to the real estate industry, and I follow Anywhere Realty and a couple other stock companies on the stock market, and their stocks took a nosedive. But after the decision was rendered, their stock price really went up quite aggressively because the market realized that these companies were actually really smart to settle before the decision came up.
Yeah, now I didn't see any numbers anywhere as to what the settlement amounts were, but assuming the information you got is correct and it's those numbers, it sounds like an awful lot of money to settle. And when they do settle, they're usually doing it without admitting responsibility or liability, but sometimes it's just cheaper to settle than to risk going all the way to the end of a trial and getting a decision. And just to put it in context, when the verdict that did come out, that did go to a trial, the award was $1.78 billion, with the possibility under their law somehow for that to triple. And I'm not sure exactly how that works, but it could become $5.36 billion. So if you're settling your part of the lawsuit for 100 million or a couple hundred million, it's peanuts in comparison to the exposure if it goes all the way to trial and a judgment. Now, we should mention, I guess, at this point, this was a verdict in a trial, and it's subject to appeal. And the parties made it clear they're appealing, and they're complaining. I'm sure that we haven't looked at all the grounds for appeal, but one of them that I did see is they said that there was certain evidence that wasn't allowed in. And you know, they're always looking for certain reasons because they got to justify, you know, what basis they're appealing, as opposed to say, well, we don't like the decision. They got to find, you know, some basis for it.
A legal
So,
basis,
a
right?
legal basis for the decision. So, you know, there was a mistake made by the judge in instructing the jury in the amount, in the type of evidence that he allowed to be admissible or not be admissible. Maybe the jury didn't. And by the way, this was a jury verdict, not a judge verdict. Maybe the jury weren't told the full story because certain evidence wasn't allowed in, and that's what they might be appealing. So we don't know where that's going to go. It's quite possible that they could be successful on appeal, and the whole thing could be thrown out, or they might end up appealing and be successful on reducing the damages. Okay, but it certainly raises the issue about realtor associations are allowed to govern, and whether it is collusion or it's not collusion if you're cooperating with other brokerages in the sale of property. Maybe you should explain what that means, David. Like, because under our system, we don't, you know, it's a cooperating brokerage system that we have here.
Yeah, so this all comes back to agency law. And the issue here is that the seller pays the listing end of the commission and the cooperation end of the commission. So they're alleging that by entering into this type of a listing agreement with the association or the board through the MLS agreement, and by having that cooperation agreement negotiated ahead of time, that it's disproportionately negatively affecting the sellers, because the sellers have to give up a certain co-op commission even before any offers are procured on the property. So what this lawsuit is really alleging is that every single MLS transaction that was sold on the MLS system overpaid on the co-op commission side, because the sellers were forced to offer a co-op commission on all those transactions. So David, that's why, you know, when the jury awarded $1.78 billion, and there's talk of it can go up to as much as $5 billion, is because they're gathering all those transactions, all those listing transactions that happened. And, you know, there could be a lot more plaintiffs, not plaintiffs. Is it plaintiffs or plaintiffs than originally they thought in the lawsuit. So now that, you know, if you sold your house in the United States in the last couple of years, and then there's going to be a time period that they're going to go back to, you could actually submit your name and become part of the plaintiffs list. And, you know, you're going to get a check for $2 or $3 or $4 or $10 or whatever the case is, after they divide $1.78 billion and the lawyers take their cut, whatever is left to address and to, you know, make those sellers whole based on the lawsuit that was argued in front of the jury.
Yeah, so part of this is just saying, when you're signing these standard type of cooperating agreements, you're predetermining how much is going to be paid on the buyer's side of this. And you're advertising that, saying, okay, anybody, you know, that buys this property is subject to a 6% commission, just to use an example, and 3% is available to the buyer's agent. So bring your buyers to this because you'll get a 3% commission. As opposed, so then if you're a buyer's agent, and you're shopping around for a property and you see two properties, one is offering a 3% commission and something else that would otherwise be offering a 1% commission, or a private system, you know, is a buyer's agent going to want to go or even show those properties to their buyer, because their incentive is to bring them to a cooperating listing, because that way they get 3%. In the meantime, it's predetermined that the seller's agreeing up front they're going to pay 6%. And there's an inherent, perhaps, disadvantage or unfairness to that, because it's for, you know, because a buyer, you know, I don't know, you tell me, you've been in the trenches. Would you as a buyer's agent want to direct your client to buy something where you can get a 3% commission as opposed to take them somewhere else where we're only offering a 1% commission?
Well, I think, the legislation and the code of ethics is there to prevent those situations. And I mean, we have to have our clients' fiduciary duties first and foremost. So when you look at it from that point of view, realtors are not supposed to be disadvantaging properties that have lower commissions. But unfortunately, there's a number of realtors that don't follow those rules. And unfortunately, it's just a sad reality that maybe this happens more than it should. But if you have your client's fiduciary duties at heart, then your commission shouldn't be the deciding factor of which property you show your client. The property, the features, and what your client is looking for should really be the deciding factor of what property you're showing to which client.
So, and we're talking about a decision that happened in the US, but there's lawsuits going on here as well, challenging the system here because we are on this cooperating broker system. And the issue is it unfair? Is it not unfair? But to me, it's sort of a fundamental question because, that's our system. There's other jurisdictions and other countries that don't use this model. They have a different model. And the buyer retains their own agent, and the buyer agrees to pay their own agent a commission. You find me a house, and I'm going to pay you 2%, 1%, 3%, whatever they agree to. They sign an agreement. Whatever the price house is, I'm agreeing to pay you directly, buyer's agent. It's not the seller that's paying you, right? It's that model, but that's not our model. So if this actually gets upheld here locally, it changes the whole system of how we sell properties here, and we're just going to a completely different model.
David, we have a very unique system in North America of how we sell real estate and how we cooperate, and it's very organized. It's very well maintained. And it's much different than the system that we have in Europe, where it's very fragmented and, everybody's kind of self-represented. Everybody has to pay their own fees. Cooperation is not encouraged. There's no multiple listing service. And I think it fundamentally disadvantages the homeowner. And what I wish would have happened in this lawsuit, I think the case that should have been presented is that our current system actually raises the net worth of each homeowner in North America because of the organization, the cooperation, and the infrastructure that's in place. That home ownership is encouraged, that buyers looking to buy don't have to pay for the realtor services through their own pockets. I think that argument should have been placed completely differently. I would have looked at the homeowner and said, Mr. Homeowner, your home went up 800% in the last 15 years. And that is through the hard work, dedication, and the drive that realtors bring to the table to work hard to help you, unlock and push the value of your house. These things don't happen themselves. It's not like, you build a house, you do nothing, and the house goes up in value by 800% over 15 years. This is the work of a whole system coming together, of a whole community, of a whole industry, and working hard in all aspects of the industry to really push and drive the value of that house up. So my argument to this lawsuit would be like, yes, maybe sellers did have to pay a little bit more than they should have. But because they did, look at what happened to the value, to the industry of each individual house, and look at, where we are and how proud we can be of the organization and the fantastic system we have in North America that the whole world looks at and marvels. And here we are litigating to disadvantage and to change it and to go back to what? Like, it's crazy, David. And I can't believe that the judge got it wrong and the jury got it wrong. I would love to know how many of those jurors were homeowners. And I'd love to know how many of their homes have gone up 800% in value over the last 15 years. That's the question I would be asking.
Yeah, and like I had a couple comments on that. One is there's nothing in our system that says someone that wants to buy a house has to use the multiple listing system to go buy a house. There's nothing that says a seller, anybody selling a house in Ontario, has to enter into one of these agreements or use an agent. You can sell privately, you can buy privately. You want to retain an agent as a buyer to act for you and pay them directly. There's nothing I'm aware that says you can't do that. Okay. But what the system allows is, oh, here's a choice. You could do that, or you could be part of this great system. And not only, so my second comment is, I know you've sort of focused on the value and the agent providing these services, drives up the value and the price and everything, but it's not all about price. The price and the values are going to go up, but there's so many other aspects to the service being provided, including all the obligations to disclose things and about the property, and properties get fixed because of these issues. An agent says, well, you know what, if you're going to sell it, we have to disclose this thing. So why don't we just repair it and fix it first? And then it's a non-issue, and there's, it's money well spent, and that'll increase the value. Like, there's so many services that are provided by an agent
That's
in
an
the
excellent
process,
point, David.
aside from the value, and all of it eventually affects the value too, because they're doing a thorough, proper job, and they're marketing the property, and they're exposing the property to so many potential buyers, and that's good competition, and that's what drives up prices too. So it's not just the price, it's the overall system that protects consumers, protects the buyer, protects the seller, by having the agents in place and all the disclosure requirements. And we're going to talk about some of these disclosure requirements in our next episode. But there's a lot of value in that. So I don't understand why anybody would want to go away from this system. I think the checks and the balances are there. I think it helps a seller. I think it helps a seller sell his property in a timely fashion with proper agreements that has a good price, a good closing date, good conditions, to work through, and it works. So, we'll have to see if the courts agree with that type of position. I suspect at the end of the day they will, but we'll see.
My only concern, David, is that you have to have a legal basis to, appeal this decision, that you can't appeal it based on, the facts at hand anymore, right? Unless the facts at hand weren't properly presented to the initial jury. So, I haven't really looked at the transcript of the trial, haven't really looked at like too many details of the trial. I've just looked at the high-level decisions that are coming out, but it's going to be really interesting to see. I think the jury got it wrong. I think that I'm yeah, it's going to be interesting to see what happens. And there's a similar lawsuit being filed in Canada. Now, I wasn't able to verify these facts, but David, I was told when I did some of my initial research that the cooperating commission in the States is fixed, and that's adding to the collusion side of the argument. Whereas anybody that's seen a listing agreement in Ontario knows that the co-op commission in Ontario is a fill in the blank type of situation. So it could vary, and the seller makes the decision of how much to offer the cooperating brokerage. So the agreement says that the total commission is X, and out of that total commission, the seller agrees to cooperate at the following amount. And you can put $1, you can put $2, you can put a fixed number in there, you can put a higher percentage, a lower percentage. The seller can make the decision what cooperation commission to offer. And we are seeing that number trending downwards in Canada, we are seeing in, certain markets like Hamilton and Burlington, the cooperating commission being offered is 2% or, a bit lower. We're seeing that in different types of markets. So there is downward pressure on that number in certain markets. But again, that's a supply and demand type of situation as well. In certain markets, the sellers have to offer more to attract the right buyer to the property. So I think given that difference, which again wasn't verified, this is something that I kind of stumbled on in doing my initial research. So I did not verify this. But if that is the case, that the co-op commission in the States is fixed in the agreements and it's variable here, I think that could go a long way to a different decision being rendered in Canada.
Yeah, and the decision here is sort of TREB has rules. Certain brokerages sign on, agree to comply with those rules, and the allegations that somehow by doing so, they're conspiring to violate competition laws in Canada. It's not fair competition. When I think you can argue that it actually leads to fairer competition because it's open to everybody to participate in it, but you want to have some rules regulating the industry. So it'll be interesting to see how this plays out in the courts. And again, in under our system in Canada, like there'll be a trial at some point, there'll be a decision, and then that's going to get appealed on some grounds. So we're still a while away from figuring out where it's going to be. But if they lose here, that means the whole system is changing, and we're going to end up being a model like they have in the UK or other places where it's no, buyer retains their own agent, buyer agrees to pay their own agent, seller pays an agent, and it's a whole different model, whole different system. And I think great arguments we made that that doesn't help a seller or necessarily a buyer either in the marketplace, because it lessens the duties and responsibilities of the agents involved, and I think it lowers the bar. It doesn't necessarily raise the bar. So I think there's less protection. And our laws, every time we get new laws, it goes more and more towards consumer protection. And we're going to talk about that in our next episode, because there have been updates to REBA and TRESA, and it's all designed about, how can we better protect consumers? So I'm really thinking these decisions are not going to go wrongly at the end of the day, but these are, for people with bigger foreheads than me and you to make these decisions, I guess.
Yeah, put us on the jury, put us on the stand. We'll make the right decision for everybody.
Yeah.
Thank you, guys. This is a great episode. Any questions, any comments, please reach out to David Korman and myself. We'd love to hear from you, especially on this topic. It's a hot press topic, and everybody in the industry should be paying attention to this, because this could really change how we transact in real estate, how we cooperate, the brokerage model. It could really affect our industry on a fundamental level. So I'd love to see more comments. I'd love to see agents getting a little bit more involved, educating themselves on the topic at hand, and participating in some of these discussions.
Interesting to see how this goes. So anyways, great to discuss it anyways, because I think it's important for everybody to know that this is in the air, because it'll affect everybody.
Absolutely. Thank you, everybody. We'll see you guys next episode.
Thanks.